Well, good afternoon, everyone, and a very, very warm welcome to the Lex Witness ninth Annual Real Estate and Construction Legal Virtual Summit edition. This event, the virtual event, is brought to you by Lex Witness, which is India's first magazine on legal and corporate affairs. And for over 10 years since its inception in 2009 as a monthly, Lex Witness has become India's most credible platform for the legal luminaries to opine, comment, and share their views. Well, we hope everyone is healthy and keeping safe. And without any further ado, to start with our program, allow me to bring you to an all new world of Lex Witness Virtual, that is lexwitnesslive.com, which encapsulates all of our digital initiatives so far across an array of industry sectors and practice areas. Well, today we welcome you all to the Lex Witness ninth Annual Real Estate and Construction Legal Virtual Summit Edition, which is one of our flagship events moving into the virtual world. After having completed 8 successful editions, the forthcoming edition is scheduled for today and tomorrow live on your screen. The summit has been one of the most preferred knowledge sharing and networking platforms for the industry professionals ever since its debut edition. Well, before we begin, some basic housekeeping rules. You may see the raise hand icon. You can ask your questions live at the end of each session. All you need to do is use the raise hand icon to join and wait for your turn to ask live questions. You can also post your queries in the question and answer box at any time, or even WhatsApp your queries to 798-277-1770, and we at Lex Witness will ensure that all of your questions are answered during the event. So moving on, the first session for today, our first session is on COVID-19 and the journey therefrom. To moderate the session, we have with us Mr. Pradeep Chaudhary, Head of Real Estate Affairs Legal at Tata Communications. And Pradeep currently is heading the real estate affairs in Tata Communications. He started his career in law in 2002 with SC Datta and Company Solicitors and Advocates, High Court at Calcutta. And then he moved on to the private sector in the year 2005. And he had been working in the private sector for the last 16 years, having worked in the manufacturing industry such as Crompton Greaves, Spencer's Retail, Indus Towers, and Uninor. Then to share with us his expertise, we have for this session Mr. Gurunpreet Singh Sarna, who is the Associate Partner at Dheer and Dheer Associates. And Mr. Sarna is an associate partner with the firm and has more than 10 years of experience, and his practice areas are projects and infrastructure, project finance, and capital market. He's a commerce graduate, LLB, and an LLM from the University of Warwick. And apart from being a part of some major infrastructure projects, he is proficient in EPC and PPP projects. And Gurunpreet has closed various transactions in project developments, in finance, in project financing, real estate projects, and infra, including advisory on engineering, procurement, and construction projects. Moving on, we are also joined here this afternoon by Jagdish Agarwal, President Legal at JP Group, and he comes with over 28 years of hands-on, rich experience of handling diverse commercial transactions, including structuring of the transactions, drafting, reviewing, and negotiation of contracts, and due diligence, litigation, and legal advice, including on tax aspects, legal compliance, regulatory, and company secretarial functions. Also joining us, Karma Bhutia, Head Legal Director, Group Services at Anarok Property Consultants. And Mr. Bhutia graduated from the University of Calcutta and admitted to the New Delhi Bar Council. He's also a Master in Business Law from National Law School of India University. And his areas of interest are intellectual property rights, arbitration and conciliations, anti-dumping, industrial relations, real estate and commercial contracts, and is a regular speaker in other seminars and conferences. We also have with us Mr. Rajivan Nair, a legal head, L&T Realty Division. And Rajivan is a legal and company secretary professional with over almost 3 decades of domestic and international experiences in legal and corporate affairs, in taxation and compliance, and his very rich experience in sectors such as the real estate and construction, infrastructure and energy, logistic and infrastructure, FMCG, food, beverages, chemical and fertilizers, steel and computer software and hardware industries. And prior to joining L&T Realty Developers as the legal head, he has worked with Oberoi Realty, Wellspun Energy, Tata Housing, Lodha Group, All Cargo, Parley Agro, etc. Last but not the least, also joining us for this afternoon session is Titash Mukherjee, Associate Partner, S. Jalan and Company. And she comes with over 8 years of experience and as an associate partner with the firm, has completed her post-graduation in business law from the University of Calcutta and focuses primarily on insolvency, dispute resolution, real estate, as well as general corporate advisory. So without wasting any time, I'm going to hand it over to Mr. Pradeep Chaudhary, who will be moderating the session for us. Over to you, Mr. Chaudhary.
Yeah, thank you. And thanks to each one of the participants here, the panelists, for investing your valuable time with us on this Friday afternoon. As had been said, I'm Pradeep Chaudhary and I'll be moderating this session, COVID-19 and the journey therefrom. So today we have an amazing panel with us, and each of them are an expert with years of experience in the real estate sector. The panel in this session will be talking about the laws and regulations and its impact on the real estate sector, especially in this current pandemic situation, and the changing trends and its impact on the real estate sector. So without spending much time and without much ado, my first question to Mr. Jagdish Agarwal, from the developer's point of view, who according to you is the good, the bad, and the ugly?
Yeah, it's a very pertinent question in the current scenario. I would put it differently. See, a chain is as strong as its weakest link. We can say that, yes, the developers proved to be the weakest link in the chain. But I think this is more of a case of contributory negligence, I would say, where a lot of people have contributed to this mess. When the markets were rising, there were investors who invested beyond their capacity. And as the market stagnated, everybody stopped paying their installments or basically the demands that were raised, construction linked or otherwise, as per the agreements. Builders or developers had to go slow on the construction. There were inordinate delays on the part of the regulatory authorities, town planning authorities. So everybody has contributed to some in some measures, but yes, the largest share of the blame would go to the developers, because they ultimately they proved to be the weakest link. They could have planned their finances well. And I think they also got into the euphoria of land bank. I think that at that time, the concept of developing land bank as if the land is going to vanish could be the reason where they basically, there was to some extent, the funds were utilized in developing new projects rather than completing the existing ones. And that approach ultimately proved to be a problem for the whole sector. I think everybody has to take some portion of the blame, but yes, one can say, and lack of regulations also. Like, I wish RERA had come in late 90s or early 2000, so that it would have like put in some discipline in the sector, which would have been good for the whole sector ultimately. Better late than never. Now I think the sector is evolving very well in a disciplined manner, and hopefully all the legacy issues would be behind us in few years.
Great. Now my next question is pointed to Karma. Karma, you being in Anarok and you being a person who deals with both the financial institutions, the developers, as well as the consumers. From the perspective of a financial institution, who, according to you, would be the good, bad, and the ugly?
Yeah. So, Jagdish, thank you for putting that piece in place. I'll bring a little bit different texture to this whole discussion. I mean, it's a great question that you are throwing in. But I think if I bring in a little bit of extra different texture, I think it helps us to look at this, in a more, more balanced view, if I may say so. Now, while that may be the contention, and the fact that as you rightly pointed out, Pradeep, we deal with financial institutions, we deal with the developers, and of course there is our end buyers like you and me who are the customers to it. Now, the way I see it is, it's an ecosystem, and it's more of in terms of the way I see it is as first among the equals. Each are dependent on one another, number one. Number two, however, the blurriness does tend to creep in the moment, as Jagdish did point out, where the contribution, or rather, when you tend to look at from a different lens to say, I need to exercise my superiority over you. For example, you would see financial institutions do exercise the superiority over developers. Developers in turn try to exercise their superiority over the buyers, and it is the buyers, if you look at in maximum of the cases that we see, who are the end sufferers now. It is a different subject that today the market is more regulated with coming of the RERA, etc., etc. But if you look more from a closer standpoint, and I think that's way again, we either as legal practitioners or either as in-house counsels have a greater role to play. And I strongly believe that there is a huge gap which is there existing in the system, which we as individual, as legal practitioners, and as legal in-house counsel can help to bridge the gap. Now, I will just, by way of anecdote and not going into the merits of the case, quickly throw in the recent judgment of the Supreme Court in Area of Grace. Now, they were not even one moment reluctant to say, we cannot enforce this lopsided contract. Now, if you look at it, take a step back, it was drafted by one of us, one of our colleagues who are sitting there, but at the same time, and they knew it at the, far end, there is no light to this particular agreement. And rightly so, the Supreme Court did manage to throw it out, saying, we cannot do this. We cannot enforce such a lopsided contract. So I think we as legal counsels have a great role to play in terms of bridging this gap and believing in that, while there is a commercial interest of each of the parties, but they can strike the fine balance existing in the ecosystem between the three stakeholders. So I think that would be definitely in the right approach, in my view, to get things aligned and move towards that direction. It's today at this point of time a roller coaster, but my personal belief is, while it is a roller coaster, it is in a right direction. So that would be my take in terms of understanding of this particular piece of this questionnaire.
Great. Thanks, Karma. Now, Gurunpreet, you being the lawyer and you being the person responsible for advising your consumer clients, not the corporate ones, not the developers, not the FIs, but your consumer clients. So where does your consumer client come in? Is he the good or the bad or the ugly?
I would rather like to second to what GC and Karma just mentioned. This is the entire ecosystem which works for establishing the infrastructure. We should not forget that the banking industry, the banking sector, is the backbone of the economy. So if there is lending to the borrowers, to the developers, There'll be projects which will be appraised. There'll be consumers the end result is the consumers will take those projects. They will take the flats which are available. The end is basically the consumers have taken it as an opportunity. What I feel during this COVID time, there have been regime changes. There have been economic packages that have been granted by the government. There have been rate of interest that has been reduced. The consumers have come forward, looked at it as an opportunity that the real estate sector is down. The investments, the borrowing has also come down because the lending is available. The banks are able to pay you more money at a very reasonable rate of interest, and consumers have taken it as an opportunity. While I would also like to add, the government have taken a real initiative during this COVID time. They have created those sovereign funds and for last transactions or funding which is to be granted to the developers for completing the projects. The government has pitched in wherever it was possible to give those breathers. Even the moratorium period was extended to a certain level to give a leeway to the developers during the COVID time. But this moratorium period does not mean that there is a waive of the installments, or you have to pay that debt out. The developers have to pay the money out. But I foresee as an opportunity for all the consumers. They have taken it as an opportunity to invest when they have the money in their hands, because the infusion of funds have been there in the industry. These packages, because of these packages, the stipulation which was granted by the government, there's been a lot of funds which were available at to the banks and financial institutions to grant. The only sad part is how to evaluate which borrower to provide, which developer to provide, because the existing developers are anyways exhausted. Most of the developers have taken that leeway of the moratorium period. They're on the verge of completing it. They have to repay that debt also. So we have to see the output of the entire post-COVID era, that what would be the output, whether the operations are going to be there, because the developers have definitely struggled. The construction sites were banned, the labors are not available, they have migrated during that COVID time. They exhausted their working capital limits, they exhausted their loans limit. But overall, if you see, I feel the customers do have an equal opportunity. They see it as an opportunity to invest their money as on date, because the sector is down. The loan fundings are available at a very reasonable rate, and they can get those loans, or they can get those investment to a right property. So on the other side, when I feel who has actually struggled a lot, I feel the financial sector is the worst impacted. That's the backbone of the economy. I mean, there are thousands of people who are working within the banking channel. Their revenue generation stream is basically business model is to earn revenue out of the interest. If there is a moratorium which has been triggered, there are no funding available. They are sitting on cash. Pre-COVID time also they were having funds in their hands, and they have after this economic package that was granted, there was no funds which has been infused. Now, because of those funds which have been infused, they have to identify which borrowers to actually developers or borrowers to grant those funds. There is an existing borrower who's already taken a leeway of the moratorium period. We are not very sure whether he will be able to pay his debts out. But I feel personally the impact is on the financial sector more than on the developer.
Okay, great. So now it's Rajivan. I believe the question that I asked, do you at all agree with this categorization?
Yes, I agree to disagree, I would say. The reasons because the categorizations are in many folds. Most importantly, the pain area. Then come to the financial impact. And then come to the impediment of growth, the viability of the project, whether ongoing project or the proposed one. And the most important next one is the reinstating the customer's confidence. And then I can quote many. Now, let us look into the one by one. So first let's look into the developers' concerns. So due to the COVID-19, the laborers moved out to the native, which created scarcity in supply or availability, which resulted stoppage of construction partially or completely. And to bring back the laborers, further additional cost. Then what happened to the customers stay away, adversely impacted new booking. Then due to the job loss, the business loss, the customers who booked under construction, they are not able to, their inability to pay the pre-EMI, seeking cancellation. And those who already taken the possession and paying EMI, but unable to pay their EMI, again impacted the market. Because the flat owners wants to sell the apartment to avoid the implications of non-payment of EMI or due to avoiding the default category. This will again increase the supply availability in flats apartment in the market. Now for the commercial leasing, the delay in payment of rent by the licensees or the lessees or the premature termination of the lease or leave-in license again leads to negative cash flow to the developers. So these are the pain area you look into the from developers point of view. And if you look into say the banks and financial institution, so during the moratorium period their cash flow is less, but outflow is remain same because they have to continue to service the payment to the FD holders or whatever continue. So next come to the customers. The customers who have booked under construction, they know that the project is getting delayed. This will lead to they're paying more rent if they are already on a presently rental accommodation. So the categorization, if you ask me, yes, whether it is who's ugly, who's good, who's bad, I would say the COVID taught us a good lesson. It is an opportunity for each one. Yes, all of us faced problems and all the categories have already learned lessons. Way forward, they will strengthen that, and it is an opportunity for improvement for each one, and plenty of opportunities are coming forward. That's what I would like to say.
Right. Thank you. Now, my next question is to Titash. Titash, my question to you is, in spite of having all the strict laws and the regulations, the orders and the judgments passed by the different courts, the Apex Court, but still somehow there still remains a sense of discomfort in the industry. And maybe that is the reason why such sort of a question has been raised. So do you really agree? Do you really agree that yes, there is some amount of discomfort?
I think the last part, could you please repeat? You were not
Yeah.
Discomfort, I heard the last part.
Yes. The query is that in spite that we have all these strict laws and the regulations, do you still believe that there remains a sense of discomfort in the industry between the financial institutions, the developers, and the consumers, the end users?
See, basically what I would say, like from my experience, since I'm into the real estate, like there we are appearing as well as working for the developers, and we are also at times, in the field of litigation, we are also representing both. So we, also for the developers, also for the consumers. So as per my experience, I would feel that after the enactment and implementation of RERA, and in West Bengal, as you all know, that it's HIRA. So after the implementation, I think there's a structure. Previously, I feel there was no such structure where the consumer at one point of time didn't know what agreements they are entering into, what projects are there. They are being promised that this is the structure that will be developed or constructed. The developer also had some, there was no sync, that I would like to say. But later on, I think after the implementation and enactment of these acts, there is a sync and there's more transparency. That I would like to say. It's more structured. But at the same time, I would also like to, I also feel that there should be some modifications maybe required in the forms, and maybe, but the spirit should be there, which has been framed in as per, the RERA and HIRA. So that's what I feel like, like my experience is.
Great,
And
great that we, yeah, please continue.
no, no, you can continue. Tell me.
Okay, so great that we have your views. And just to sum up this particular topic, I would say that yes, we had surely come a long way with the implementation of the RERA.
Yes.
But as being the common point which had come out from each of the panelists here, what is important is to accept that the rhythm of this ecosystem must go on uninterrupted. And this is the only thing which would ensure further development and progress for the industry, and which would be beneficial for all the concerned stakeholders.
See, I think yes, there is always a fear among the developers as well as the consumers. Like, where shall we go? Like, the consumers have a feeling, they have an anxiety, as you say. There's a discomfort. I mean, a bit of discomfort is existing in all the industries, as well as the financial sector, as Gurenpreet has rightly pointed out. And yes, as Karmaji said, that there's an ecosystem. It functions. It's a chain, and how it works out. So I feel that discomfort is presently there to some extent, and also owing to COVID. But I feel this discomfort, with time, over time, as we get used to it, I think this will, slow down and things would change. Like, that's what I feel. Because
Yeah.
previously I felt there are more complaints and there was lack of transparency. That's what I feel. People didn't know where to approach, where to go. Like, they are like false promises. The developers didn't know, the banking institutions didn't know when is the project is actually getting completed, and where to, like when they are going to get the return back. So there were a lot of issues arising from all the sectors, from banking, from the consumers, from their own point of view, as well as the developers. So I feel that it's a platform right now. It's more structured, I believe, and I think there's a scope. There'll be more changes coming up, and I think it will ease up. That's what my that's what I.
Yes, yes, the platform is built, and we need to further emphasize on this particular platform. Yeah. Now, moving forward, because we have a paucity of time, and I'd request each of the panelists to just look into the timelines that we have. Now, going into the next topic is monetization of the real estate assets. Now, my question to Gurenpreet, if you can just tell us, with regard to monetization of the assets, what, according to you, are the advantages in the present day context vis-a-vis the local land laws and the COVID-19 scenario? Maybe just in bullet points, if you can just tell us.
Yeah. See, we all know monetization of assets means that wherever you have an asset which you are not being able to utilize, it's completely idle and you're not earning revenues out of that. You want to encash that opportunity of utilizing that money to some other core area of your business. So I would just divide my discussion into two parts. One, companies, corporations, and governments have identified themselves into two aspects. One, what is the core area of their business where they're earning revenues, and what is the non-core areas where they have assets which can be utilized to bring in funds from capitalizing from the assets which have not been utilized, or how to monetize them. During this COVID time, the companies, what I personally feel after the COVID time, these companies, corporations will make a strategy, a plan of action, that how to reduce their debts, because they will exhaust their moratorium period. They have to pay their funds back. They will start capitalizing that opportunity to identify assets which are non-revenue generating, to encash it. As a simple example, they can go for a sale deeds, sale transactions, bring in for money, and utilize it for the other sources where they can reduce their debt. But it comes with a cost. It's not as easy as possible. The advantages are, as I mentioned, they can reduce, they don't have to dilute their equity if they have assets available. They can also lease it out in a different model to bring more money. The only concern here is the disadvantages, because if they have assets, they've mortgaged it to some bank, they have to go for NOCs, stakeholders are involved, any permissions, the tax implications, the income tax is involved, the capital gain is involved, which will eventually have an impact on the capitalization of the assets. Now, this will be the post-going factor of the or a strategy which will be adopted by the companies going forward. from a government perspective, the government prior to the COVID times are already doing it. If you see the last 2019-20, government has come up with disinvestment plans of action. They've done a lot of disinvestment where they have capitalized from the assets which were from where they have started earning revenues. So they were always there. They were always there. It's not the COVID time which has made them realize that they have to start utilizing. Even as on date today, the highest land bank which is there with the government. They have industrial parks which they want to lease out. They have huge warehouses that they want to lease out. They now and then they keep on hiring the big fours or the transaction advisors to keep on telling them which model to follow to bring more revenues. And these days, the PSU buildings has also been they're trying to revamp with the opportunity of capitalizing it by leasing them most of their portion leasing out to private sectors. So they have always been there. Even the government has taken this initiative, and going forward, even the railways, if I may give you an example, recently the railways are getting privatized. They are utilizing that opportunity of asset monetization there as well. Now, from a land loss point of view, I would say one of the states during the COVID time, like Karnataka, was one of the quick enough to make certain amendments to land laws. Earlier, there was a restriction that in case you want to acquire a land, any company wants to acquire a land there in Karnataka has to take a permission from the government or a collector to set up a project. Now, if this exemption has been given, this restriction has been removed recently by way of an ordinance, which is still as active as an ordinance in the past. But because of this, many of the companies which were not able to acquire agricultural lands also, which government had as a land banking, or even for that matter in the rural area, the rural farmers were not able to capitalize those lands because they needed a permission to sell those properties. So all this changes we have seen during the COVID times, and I feel going forward, the corporations are going to prioritize themselves. They will make strategies to so that they can reduce their debt without even diluting their equity stakes.
Great. Now, my question to Jagdish, on that same flow, according to you, what are the disadvantages?
See, as far as monetization is concerned, in my view, monetization is the mantra for developer. To put it simply, I can take an example of jewelers, means analogy. Howsoever beautiful masterpiece a jeweler might have created, but if he get emotionally attached to that masterpiece, he has to shut his shop. So similarly, if a developer doesn't want to monetize his assets, means monetization could be through REIT or through rental model, like DLF has created a used asset base which they are giving on rent. That's also one way of monetizing it. But yes, monetization is essential for a developer to grow and to meet their financial obligations. As far as the advantages and disadvantages are concerned, I think the biggest disadvantage in monetization is the stamp duty. The states have like very high stamp duties. Some states have 8-9% stamp duty, and that makes the real estate assets very illiquid. One reason is, yes, that people invest in real estate for long term, but stamp duty also discourages people from investing, say, for 2-year, 3-year, or 5-year. Means unless you invest for 10 years, you can't make money in real estate because 2-3 years appreciation, the stamp duty and the transaction cost itself will take away. So the biggest disadvantage I see is the stamp duty, and maybe some consistency and some uniformity in the state laws across the country. And in the REIT, I think one of the disadvantage of TDS on the dividend, that has been taken care of in this budget. And now I think the biggest piece is the stamp duty, and the government of Maharashtra did a good thing by reducing stamp duty in the Corona period. And we have seen the result. The property transactions and the registrations have gone up hugely, and the government has in fact received more revenue than what they could have received if they had not reduced the stamp duty. So there is a very clear example before us now.
Great. In addition to what Jagdish had put uh, in my personal opinion, I believe one of the other disadvantage is the uniformity of the land laws, because the land laws in each of the states, it varies to a huge extent, and that also acts as a barrier in the monetization of the surplus assets that each of the entities they possess, even the government also. So now, my question to Karma, you had quite a bit of experience in PPP projects, wherein with the involvement of the government and the private partnerships, what according to you are actually affecting these PPP projects, especially during this pandemic time?
Okay, so that's a pretty heavy question, but at the same time a brilliant one. In fact, I was just a while back attending the India-Japan arbitration modalities, and one of the key pieces that we discussed was, or rather was in discussion, was in terms of the investment friendly in terms of the Indian environment. Now, if you look at it, and this is just for the general understanding of all the viewers who are on the screen. So while Pradeep that did mention PPP projects, it basically just stands out just to be on the same page as public-private partnership models, where the governments and the private players come together. Now, of course, it's a marriage between the two, right? And primarily because this is the private companies have the technology, the innovations, and of course the money. And end of the day, the business are done to make money, and we have the government who will support by means of various treaties, by means of various MOUs, etc., etc., etc. Now, and there are different modalities to it, how this kind of transaction can be carried out. It can be carried out through build, operate, transfer, build, own, operate, etc. Again, there are various names to it. And just to get you one step closer to the subject, the toll gates that you see in various highways, etc., are under certain one of these models that you see. Now, while that is at the back end, and just to get you familiar with the subjects, it is not as rosy as you think on the ground level. Now, there are various, again, reasons attached to it. One, primarily, as I mentioned, is always about whose paper are we going to do business on? Is it going to be my paper, or is it going to be the government's paper? And in maximum number of the cases, because they have called for RFQ, which is request for quotation, request for proposal, it is always on their paper, number one. Number two, with that comes the first step to the problem, which is now in terms of negotiating those clauses, which in my view and as per my experience, many of them are obsolete. They do not, or rather they are not even in sync with the latest judgment or with the latest orders, etc., etc., etc. Which also means that if you fast forward yourself and see yourself, if there should be a litigation, how will this pan out? Now, if you look at it, before you diffuse the core issues, you will have to diffuse the ancillary issues, which either has already been decided by various courts or has been sealed by the ethics code, which also means huge burnout of the business hours and more billing by the law firms and your counsel, number one. Number two. Number three, most importantly, is the governments are not very active or proactive in coming to the table to say that we are partners here. I look after your interests, you look after my interests, and that's what we're gonna get going about this. That's number two. Number three, face it, don't like it, but there is a huge lobbying that happens at the back end. And as a result, because of that, it generally goes for a spin in most of these contracts. Now, the list can go on. The list can go on, and I am conscious about the fact of the time that I need to maintain. But even then, the bottom line in which I would submit is it's in a right direction. It brings in huge opportunity in terms of employment, investment, etc., etc., etc. And therefore, it has a tremendous opportunity of this particular partnership, if done in the right manner, by bringing the right ambience to both the parties getting into this agreement or getting into this relationship.
Yeah, thanks. Now, Gurunpreet, in 30 seconds, since we do not have much time, in 30 seconds, what according to you are the best possible means of overcoming the legal hurdles? 30 seconds.
So I'm not gonna not gonna push on the negative impact which has happened on the industry, including the infra side, which has already been discussed by Karma. How to overcome, we are going to foresee a lot of renegotiation of the contract, which is going to reopen. We also see there'll be compensation clauses which will be built in later on. We will be seeing a lot of as I mentioned, negotiations would be there. There will be bridge financing, because once the period of moratorium is completed, there will be loans which are outstanding. As I mentioned, they have to be repaid. There will be again working capital facilities would be required. So in order to overcome the issues, there will be renegotiations which will reopen. The company is going to have those compensations. Force majeure event is definitely going to be there. It's anyways part of the contracts as per because the government took that initiative in very early during the COVID time to incorporate as an event of disturbance in supply chain. That is definitely going to be there, and we will also foresee all those events and additional events to be part of force majeure, so that there should not be any legal hurdles which may arise similar way we have seen in the COVID times.
Great. Titash, 30 seconds to you. What, according to you, are your views on the force majeure provisions in this PPP concessions? Maybe you can just sum up the three major items.
Yeah, so basically, PPP does not have, no unified legislation as such, but these are only based on the guidelines, plethora of guidelines, policies, manuals, okay, the sectorial legislations, and most importantly, there's a contract. That's the main key. So it's based on the contracts, how it functions. And regarding the force majeure, what I feel that there's been an extension with regard to the projects in view of the memorandum issued by the on May 13, 2020, by the Ministry of Finance, wherein it was mentioned that there'll be extension only on those contracts where there was a force majeure clause. And in February 19, 2020, where it was declared, I mean, when COVID didn't actually, the lockdown and all this didn't occur, prior to that, there was this notification when the government of India declared this COVID-19 as a natural calamity. So in view of that, so this can be invoked in the contracts where there are force majeure clause, and accordingly the extension would be available. But of course, it depends on how it is being extended and on the basis of the individual contracts. So
right.
It will entirely depend on the contract.
Right. And as we all know that, yes, the entire world had faced this pandemic. But yes, as we all know that the show must go on as well. So to keep the show moving, we have to devise the path, eliminate the risks and the uncertainties. And be it in the case of monetization of the assets, the PPP projects, or the other developmental activities. There's a lot of stake for us all. So now my next question goes out to Jagdish. According to you, what are the key derivatives for the lease rentals as an operational debt? You have a minute time, please.
Yeah, sure. See, this under the IBC, this issue has just come up, whether the lease rentals qualify as operational debt or not. We have two contradictory orders from NCLAT. And the genesis of this issue is the definition of operational debt, where it says that your claim must emanate from supply of goods or services. This is under section 521 of IBC. Now, in both these cases, this issue has come up whether the lease rent means the lease itself is a service. And if it is not a service, then whether lease rent can qualify as operational debt or not. We have two contradictory judgments. The latest one is Anup Sushil Dubey coming out from Bombay NCLT, and then the NCLT in this judgment held that yes, the lease rent can be treated as operational debt, and the claimant can file for IBC. In this case, there was a leave and license agreement. And in the another case, M. Ravindranath Reddy coming from Hyderabad NCLT, in which case NCLT held that no, lease rents cannot qualify as operational debt, and they dismissed the admission of the petition under Section 9. The whole genesis is whether lease qualifies as a service or not. Now, the lessees are paying GST on their lease rents. So GST certainly treats leases as service. Now, I think Supreme Court would finally decide on this, whether the lease is a service or not. In my personal view, it should be held as a service. Otherwise, it will create a lot of issues, because then it will create another risk for the real estate developers, particularly who are in the leasing model, where they will see higher risk. Means one of the avenues for forcing their recoveries would go away if leases are held not to be a service, and then the lease rental doesn't qualify as operational debt. So that's the issue as of now.
Great. Karma, a quick question. Again, I can just spare 1 minute of time. According to you, what are the market expectations or the roles of third-party mortgage under IBC?
No, you've been unfair to me. Jagdish gets 10 minutes, and I get to sum up everything in 1 minute.
I know, and I sincerely apologize for this, Karma, but we have a paucity of time, so please.
Fair enough. So I take that. I feel today that I'm just before the honorable judges.
No, not at all.
Yeah.
Not at all. Take your time, Karma. Take your time, please.
No, very quickly. IBC has gone through lots of topsy-turvy, if I may say so. From the way it has been initiated till date, it has gone great changes. It has gone many of those provisions which are extremely favorable to either the consumers by way of including the buyers in it, etc., etc., etc. But of the recent judgment of the Supreme Court in JP did not strike the right note, and I say this with the right note because I think there is still a room to impress the judges to say that, look, we have a very valid point of argument, and therefore the judgment of JP could be overturned. That's my optimistic view. And I say this because if you look at the judgment at a closer, distance, it did factor in a couple of pieces in which, for example, it's not by, it's by way of, I would say, so totally reliance on the earlier precedent of, Swiss Rivens, in which they had made to say that, this category of, the financial credit does not belong under this particular piece of legislation. Now, why I say this is again interesting fact of that, because I think the parties do agree, and I think hopefully it would be in the interest of all of us that they do push for the review and get this sorted out. And I remain optimistic that the honorable court will take one step back and look at it. Now, if that were to happen, it would be a great, tremendous development in terms of including the mortgagee under the bracket. So once that happens, I think you would see, at least from the Indian both banking, financial as well as the business environment, a optimistic view in terms of being secured to carry out such nature of transaction. So since you give me 1 minute, I could go on. Of course, I thought I'm just closing with a very optimistic note here.
I do agree, Karma, that there is no doubt in saying that deliberations are going on this judgment, and maybe, as we have pointed out, maybe a review at a future date, just to revisit and maybe re-argue on the points, the expressions. It might happen. Yes, absolutely.
Yes,
Now,
that would help. That would help, in order to at least shape up the trajectory and the development in which we are going. Then, seems to be hitting a bit of a bump, but I believe that this bump is just temporary.
yeah, and uh, maybe you never know. Maybe in the near future there might be things that will be coming up, and maybe people might think it to be wise to go for a review. But till the time we have the judgment, definitely we have something in place to
Yes.
abide by.
Yes.
So thanks, Karma. Thanks a lot. Now we move on to the next topic, wherein I'd request Rajivan, who had been silent for quite a time now, uh, and the discredit goes to me, Rajivan. I'd request you to express your views as to how the three labor codes 2020 would impact the real estate sector, and your concerns, if any, on that.
Uh, First, I think it's whether it's a 3 or 4 labor codes. I think it is a wage code, security, SS code, as well as OHS and IGAR. It's a 4 code, no? Anyway, whatever it is. So I think let me summarize what most important key changes. Okay, so that out of these 4 key changes, which are the one impacting the real estate sector. So one is that this lays down of the lays down is made very relatively easy. Second one is the reducing the union conflict. The third one is the setting the minimum wages, and the fourth one is extending the social security net, and the fourth one is recognizing the fixed term labor. This is the 4 1. Fifth, 5 important key changes I would say are impacting the real estate. So the first 2 the lay down of the as well as reducing union conflict, which will definitely will help in real estate sector in the sense. Just now, a couple of minutes back, we discussed about the monetization of the land. So predominantly, for monetizing the land, there are a couple of permissions required. One of the most important permissions is the closure of the factory permission. For the closure of the factory permission, it takes a large time to get the permission because of the union involvement and the closing and the employees labor's involvement, etc. So if this codes comes, and it will reduce the timeline, and I'm sure that is getting the permission presently, which we could say under section 25O, which take a longer time, that will get reduced. So that definitely a good impact, positive impact in real estate sector for monetizing the land, mostly for industrial land converting into residential or commercial. The second one is the third one is I told you the recognizing the fixed terms. Today, if you ask me whether the developer, most of the developer across India, they don't have their own construction company because most of them they outsource the contract. So because of reason is that they can't employ the labor throughout the year, or once the project is over, they have to deploy those labor to somewhere else. So they have to have the continuity of project. Keeping all this in mind, most of the developers they outsource the labors. But this recognizing the fixed terms labor comes, then that would be definitely be helping the real estate because if say our project is for 5 years, one can employ labor for 5 years, or if it is required for say 6 months, that provision is also there in the code. The other is extending the social net, that is security net. That is a positive impact, though it will have some kind of cost escalation in construction, but it will have a positive atmosphere in the labor categories and labors, because they will be secured more from the security network. These are the, I think, because of the paucity of time, I would like to shorten. These are our effect in this 5 category. 3 are very positive for the real estate segment. One is neutral, and one is negative, because there will be a increase in cost. Increasing the cost is the setting the minimum wages. See, today if you look into Maharashtra or Mumbai, the laborers are coming from the neighbor states, because neighbor states the labor wages are very less. So if the wages are set across India the same, then that the wages cost will increase. That will impact the construction cost. That's all, Pradeep. Pradeep.
Thanks, Rajivan. And to say, I would feel that it is a way of streamlining and consolidation of the different statutes, so that the benefits of these statutes can be passed on to the stakeholders. That would be of the prime interest, the reason behind which this consolidation is done. Okay, now my next question goes to Yes, Rajivan, please continue.
Yeah. That's all. Continue.
Yeah. Now my next question goes to Karma. Karma, since with regard to the DCPR 2034 rules, can you just provide us a quick overview on the key changes that are happening?
That's a heavy subject, so I'm not really sure that I can do justification.
Maybe Jagdish or Rajivan, can you please pitch in and just provide us the
I was coming to that. Let me just add a few pointers.
Sure, please.
I understand that it's a heavy question because it's a heavy topic, to say, that involves that much of nuances that is involved in the subject. But I'll come up with few, 2-3 pointers that one, it's a very ambitious blueprint. Number one. Number two, to see, more than anything else, what is important and what we have seen in the past and what we would like to see is to what percentage of that blueprint can they execute? Because that is primarily important. Because if you look at the earlier 2016 and, which is again, this is available in the public domain for most of the viewers, whoever are there, the execution has been very low. Now that's a challenge. It's like the manifesto of the election. You might want to set in different things, but you might end up giving only 5 of those in a span of 5 years, right? So similar-wise, it depends on how well can the existing, authority will be able.
I believe there is some technical glitch at Karma's end. Yeah, I believe there is some technical glitch at his end. So my next question goes to Jagdish. Yeah, Karma, are you there?
Yeah. Did you
please continue, please.
Yeah. So my point was how effectively they're going to implement it. So little too early for me to comment at this point of time. So I would be on the side to say I would adopt the wait and watch policy to see how this pans out.
And Karma, I couldn't agree more, because that was the same thing that I was supposed to ask Jagdish as to how effective these rules would be in addressing the current challenges and attracting the future development. The point that you have just raised, I just couldn't agree more. So Jagdish, a quick overview of yours on that, please?
On the labor code,
No, on the DCPR rules, the how effective it would be in the addressing the current challenges and or making the future development as it promises.
oh, sorry, I couldn't catch. Your voice is breaking.
Am I audible now?
Yes.
Okay, okay. So now I'm going to Rajivan. Rajivan, there had been a recent Punjab and Haryana High Court order with regard to the adjudication of complaints and consequences vis-a-vis the perspective of the RERA authorities of various states. Would request you to, if you can just make a quick presentation on that, that would be quite helpful for all of us.
Sure, Pradeep. Just before going to the presentation, I would say the Punjab.
Rajivan, are you there? I believe there had been some technical glitch at Rajivan's end. Am I audible to all of you? Okay, here he is.
Yeah, this present is slides is visible and
Yeah,
audible? My voice-
absolutely.
So let me take it this Punjab and High Court what is talking about then ratio. So its order is I'm not before going to that. Let me just give you some analysis. See, these are the orders so far passed by some of the RERA authorities. Most of them are barring Tamil Nadu and Karnataka RERA. Most of the orders passed by whether it's a Maharera, whether it's a UP RERA or Gujarat and Haryana. All these are passed by the single member. I'm just emphasizing the single members because the ratio and the issue is on whether the single member can pass this kind of order. Okay, so what the ratio of the Punjab and Haryana High Court saying that is there are two kind of adjudicating authority. One is adjudicating authority appointed under section 71 of RERA, and other one is the authorities which consist of under RERA authority consists of minimum 3 members, that is including 1 chairman plus two members. That is the minimum member required for forming the authority, and across India all the authorities are formed. Authorities are formed with the 3 members including chairman. So the judgment is saying that only the compensation, if you see that green highlighted portion, the adjudicating officer has the power only to look into the compensation, nothing more, nothing less. In all other, whether it's customers or complainant are seeking the refund or interest or any other kind of the complaint, that should be adjudicated by the authority. I told you earlier also, the authority means the chairman plus 2 members. So just based on the Punjab and Haryana High Court judgment, I just would like to visit some relevant sections of RERA. So as I indicated, section 71, which is empowering the adjudicating officer to adjudicate the complaint. But the section is very clear. One is talking about only the compensation. Second, the adjudicating officer can only look into 4 sections. That is section 12, 14, 18, and 19. Nothing more than that. That means adjudicating officer can't travel beyond these 4 sections. And most importantly, the adjudicating officer should be a judicial officer. That is the section 71 talking about. As I told you earlier also, section 21, they're talking about the authority. The authority consists of chairman and not less than 2 whole-time members. Then other one is the section 81, that is a delegation. So the authority has the power under section 81 by a general or a special order in writing to delegate the power to any member of the authority or any other person. So that delegation is, they have not restricted the delegations anywhere, except they're saying except the specified under section 85. So 85(1) is another section where the authority has the power within 3 months from the date of the authority establishment to come out with any kind of regulations. There are two ones. So one is about the delegation, that is under section 81. Then section 85 for establishment of various rules and notification and regulations. The subject matter of the Punjab and Haryana is of the regulations 85. So this is little, I don't know whether it's readable, but let me come to this. Maharera, UP RERA, Punjab Haryana RERA and Gujarat RERA, they come out with the regulations. They're saying in terms of the section 85, they're saying that we are empowering the single member or the chairman alone to decide the adjudication of the complaint. So the crux of the matter is decided by Punjab and Haryana High Court is on section 85. Whether the section, the regulation 24 of Maharera or whether 24A of UP RERA or similarly regulation 25 of Gujarat RERA, all this talking about the single member can adjudicate, which Punjab and Haryana High Court said, looking into the regulation 7 of Punjab RERA, saying no, it is ultra virus, he can't do. Because the authority established consisting of the chairman plus 2 members should be looked into the complaint. He cannot delegate to a single member and take the decision. So these are the four, 5 states I just quoted. Many other states also come with similar notifications or circular to delegating the power to decide by the single member or the chairman alone. So the question arises is whether the question 81, whatever the delegation of the power under 81 is given to a single person of the authority or any other person who is not a judicial officer, whether the complaint can be adjudicated in a judicial manner. The similar question is also arises for the regulation passed under 85 for empowering the single member or the chairman to adjudicate the complaint or proceedings, whether it will be done in a judicial manner. The third one is that whether the doctrine, the principle or doctrine of ejusdem generis will apply when the authority establishes the regulation in terms of section 85. Now, let us visit once again what is the section 85 talks about. Section 85 talks about the following. That's in terms of section 85(2), if regulations are made, the same may be for the following. 1, the form and manner application fee, that is under section 4(1). Similarly, the form of applications and fees for registration under section 6, the information and documents required under section 11(1)(f), display plan specification under section 11(3), preparation maintenance of. So if you look into that A to H, these all are talking about some kind of administrative work or forms. But under section 85(2), there is one more subsection clause, that is I, which I highlighted in yellow. Any other matter which is required to be or may be specified by the regulation in respect of which provision to be made by the regulation. The question is under this sub proviso whether the authority can establish a regulation whereby the adjudication procedure can be given to the chairman alone or a single member of the authority or any other person. So that is the crux of the issue. So as I said, the 85(1), 85(2) subclauses, sub provision talking about the what I highlighted in yellow. So obviously, this should, whatever the power given under 85(2)(1) is most of administrative power, but even 85(2)(I) should also go in the same lane. It cannot say, the authority can say, so, oh, I have the power. The authority act has given a power under 85(2) to do anything. So that is not the intention of the act. That is not the intention of the lawmakers. So because when you are, the authority have a particular function and power to, most importantly, the complaints received by them has to be adjudicated in a proper manner. If that is being delegated to a single member, whether it will be executed in a proper manner. So if the regulation passed is under in terms of section 85(2)(I), if it is ultra virus, which is what the Punjab and Haryana High Court said, it's ultra virus. In that case, the similar regulation which I mentioned earlier, the regulation 24 of Maharashtra, regulation 24A of UP, regulation 25 of Gujarat RERA are also ultra virus. So now what happened? The subject matter is now is before the Supreme Court. Even Punjab, so even Maharashtra Bar Association is intervening in the SLP filed before the Supreme Court. But Supreme Court said, don't jump in, don't come to me. You first go to your High Court and let the High Court decide, as has been decided by the Punjab and Haryana High Court. Similarly, so what happened to the Bar Council of Maharashtra? They have withdrawn the impleading application with the liberty to approach the High Court. So now the Punjab and Haryana High Court rightly said the order regulation passed under regulation 7 of Punjab Haryana regulatory RERA authority, sorry, Punjab regulatory is ultra virus. So the order passed by the single member or the chairman alone is null and void, and the adjudicating officer can do only one thing, nothing beyond that. He can only decide only compensation, not even the cancellation, not even interest delay, interest cancellation, all other complaints other than the compensation should be adjudicated by the authority only. Again, the authority, I re-emphasizing, authority means the chairman plus 2 members. Now, I told you that Maharashtra is already withdrawn from the impleadment application. They might move to Bombay High Court. I have no visibility on that. Now, the issue I'm saying, what can now Supreme Court decide? What will be the final order of Supreme Court on the SLP? Now, so can Supreme Court say, keeping in your view of the larger interest, because many orders have already passed by various RERA authorities across India, which predominantly favoring the customers. If the Supreme Court says, sorry, the order is, what is the law is saying, it should be adjudicated by the 3 members. In that case, suppose Supreme Court says, sorry, whatever the order passed by all these authorities null and void should be re-adjudicated, then it will have a lot of impact on the order passed by the various RERA authorities, and it will have a negative impact in the customer complainant sentiments. And so we all are looking what kind of order Supreme Court will pass on this SLP, on the Punjab and Haryana High Court order. Okay, so we have to wait and watch what the order will be of the Supreme Court. That's all because of time.
Sure. Thanks, Rajiv, for providing an excellent summation, I would say. Now, just to end up this session, I would like to have an open house question, and anybody can pick it up and answer. But we need to be quick because we had already crossed the deadline by 15 minutes. So just a short and quick answer. At the end of this particular session, do you really feel that the provisions under the CPA or the RERA and the IBC, all of this combined together, do you say that these are over-regulated? Anyone from you can pick it up.
In
I
short
will,
term,
yeah, I will quickly go in first and just express my, points in a very short one. So one, I think, if you look at from the regulation standpoint, I think it was much required, and we can see the difference in terms of having it and not having it, right? And these are amply displayed, number one. Number two, I think because today, and I speak primarily from the consumer standpoint of view, and as Gurunpreet was mentioning a while back, as a consumer, I know where to go today. I know what are the remedies that lies in front of me. And with that, the beauty is, the IBC has opened its doors. And Fora was always there, and comes the RERA. Now, just see, it's a matter of, fulfilling different criterias or the parameters, if I were to say so, you can exercise either of this. And that itself, I believe, in my view, it's a huge milestone, at least from the India standpoint, which we did not get to see, a few years before.
Anybody to add on that?
yeah, in short term, it appears to be over-regulated, but I think there is a lot of overlap between consumer protection laws and RERA, which with the time I think will get resolved. IBC and RERA also there is overlap, but only in case of the developers facing IBC proceedings. In other cases, there is no such overlap. And I believe once the RERA acquires teeth, in the sense RERA authorities as of now, in some cases, in some states, they are very active and effective. But in some cases, some states, they are not so vigilant or so proactive. Once the RERA becomes a really effective authority, then I think the other forums, consumer would stop going to other forums and the RERA would become the nodal agency as far as the consumer, as far as the home buyers grievances is concerned. And RERA would act for the developers also, because in many cases, now RERA authorities are directing consumers, the home buyers also to honor their commitment. So I think the RERA would become a nodal agency for both developers as well as the home buyers.
Right.
Pradeep,
Yes.
I have one point to be, if Jagdish finish, I have one point to be discussed.
Yeah. We have very short time, Rajivan, so you have to be quick, please.
I'll be very quick. I don't know how most of you must be aware. Recently in Bombay High Court, Justice Menon passed an order saying that MOFA won't be applicable for MMRD Act. Okay, it's going to be an eye-opener for that also. If it's so, though the further question is asking, because the RERA is a new act, if the RERA was there earlier, whether that would also not be applicable for MMRDA? If it's so, we have so many SRA, Slum Rehabilitation Authority, separate authority, then we have the MADA separately, then we have the SIDCO separately, then we have many such authorities conflicting of interest. All this will have a different viewpoint.
Well, that might open up a new Pandora's box. So we have to keep that for the next session till we meet. So Samriddhi, any questions to be asked to the panelists here?
Hi. So I think we are really out of time at the moment,
I know.
and we will ensure that we get back to all of our, if there are any other questions, we will get back to each one of our audiences with the answers. For now, I think we'll have to close the session. So thank you once again, first of all, Mr. Chaudhary, for having so flawlessly moderated the entire session, and to each one of our panelists here for sharing with us those valuable insights, for taking out time from your busy schedules and joining us on this Friday afternoon and talking to all of us. Thank you once again.
Thank you. Thank you.
So we'll now, with that, we are going to move on to our next session, which is on the buck stops here, funding and more. And we already have all of our speakers for the next session who've joined us already. To moderate the session, we have with us Mr. Sudhir Goenka, who is CFO and CS at Hero Homes. And Sudhir is a seasoned finance professional possessing over 25 years of experience in corporate finance, in financial planning and analysis, business and strategic planning, fundraising and operations. And he is a member of the Institute of Chartered Accountants of India, Institute of Company Secretaries of India, and the Institute of Cost Accountants of India. Also joining us this evening, Mr. Atul Bansal, CFO, Experion Developers. My apologies. Atul is a chartered accountant by profession and comes with over 24 years of experience, out of which the last 14 years as the head of finance for different real estate companies. And currently he's working as CFO with Experion Developers Private Limited, which is a 100% FDI funded company. He is also the head of the real estate CFO group and has a rich experience in M&A, in raising equity and debt, and has worked extensively with all of the major financial institutions and banks. And we also have with us, lastly, Snehashish Sen, who is the associate partner with S. Jalan and Company, a law graduate from the University of Calcutta, having passed out in the year 2012. His area of expertise and practice experience includes majorly all types of commercial litigations and litigations before all courts and tribunals in the state of West Bengal. Mr. Sen also has experience in conducting outstation works and has also worked on several outstation assignments of several clients, including appearances before the NCLT Allahabad bench, District Court at Ranchi, and Arunachal Pradesh. His area of practice also includes arbitrations. So without wasting any time, I'm going to hand it over to you, Mr. Goenka, to take this session forward. Thank you.
Thank you, and good evening. I believe I'm audible. You can hear me clearly? Yeah, thank you. So, without wasting much of time, I think the topic here is the buck stops here. So obviously, we finance professors know that everything, the buck stops at us, and we are the goalkeeper and gatekeeper of any organization whenever we are responsible, wherever we are responsible. So all said and done, anybody can make, we cannot. So I think Atul and other finance professionals will definitely echo my view that that's where the buck stops. But here, the buck stop here is more like to do with the funding issues and challenges that we are facing. Last 1 year has been something of a very, very dramatic in our lives and which has never been witnessed by anyone or even a generation before us. When I don't think any one of us. So this is quite a unique situation, and when the pandemic occurred, the first thing that we as a finance professional get to ensure that you need to make sure your cash flow is up and running and you're able to manage your operations to the best of the ability. So that's where the initial challenge was. The idea was to conserve cash and to work within those means. So we rode through a very, very challenging times. Even the construction got stopped. There were no sale in the real estate sector, no collection also. I remember the first 2 months, we almost survived without any collection based on our resources. So that has been very challenging. But over the last few months, the things have improved. And in fact, improved to an extent that even today, RBI governor told that there is a dramatic improvement in the real estate pickup, the demand has picked up, the sales are moving up. And that trajectory is seen by all the developers across India. This is more so across South India, but even in North, we have seen things improving a lot. And this has been a result due to the, I think, overall the confidence that they have come, the exuberance that can be seen even in the stock market right now. We crossed 20,000 today. We crossed 15,000 in Nifty as well. So that exuberance is there. I don't know whether it is irrational, but I don't think it's irrational. Even though the valuations looks a bit stretched right now, but there are positive signs to the economy and growth right now, rather than just a use save for whatever W or K or whatever the alphabets we were thrown into. So I'm firm believer that we are now looking at V-shaped growth. So that has been the situation so far. So I want to start my discussion on how the debt market has behaved for real estate, and maybe so if we could say that how it has been working for real estate and what has been the dynamism so far in real estate of the entire debt market.
Thanks, Sudhir. Hi, Synesis. Hello, everyone. See, honestly, real estate and debt market, they are two distant corners right now. Because real estate is always treated as I'll say a rocket DB by the by the finance market. They feel that real estate is every penny that they put on real estate, it puts their money into a greater risk than this. Then it actually supports the economy. Rather, I'll say, if you see in terms of total NPAs across segment, real estate is not the biggest culprit. Real estate, in fact, has been delivering the highest return for all the banks and institutions. And thanks to RBI also for the provisional norm that they had. Still, banks are generally very to lend to real estate, and that because of, I'll say, only because of few cases where the lending has been bad for the banks, and there have been issues with the recovery. And but now with RERA in place, and now with now a lot of governance in place for real estate also, debt market should have been more supportive, but right now it is not. So banks generally are not giving fund to real estate. NBFC was the biggest support in last I'll say 4-5 years. So now with the NBFCs facing their issues post ILFS in their backyard, so the support system is not there. PE funds, they've been investing high in India and also in real estate, so that has been a dampener. So not much of PE fund coming in India. So the right now the situation is not very good in terms of debt market for real estate. Not much money flowing in, and not much options there in the market. There are still banks who are funding it, but not too many banks are funding it. There is still a lot of stringent conditions for them. Rates are very high, so that's something which is and the margins are falling for real estate. So that is the situation is definitely not very encouraging in terms of debt market for real estate in India.
So where does one go from here? So what are the alternates that one can look in terms of real estate market?
See, that is the biggest challenge that we have. If you look into other arounds anywhere, China, if you see, the real estate has developed so vastly in last 2 decades, and fortunately I got a chance to interact with few developers there in China. I've been traveling to China a few years back, and so there the support system is very high. They have a central bank authority like we have RBI here. So there they have created a kind of a insurance for all the lenders who support to real estate. So they create kind of a insurance policy where whatever lending they're giving to real estate, it is back to back insured for the banks. So banks, even in case of any default, banks do not lose money. So that support system is not there in India. So I think framework wise, RBI started giving some stimulus last year. The first time after so many years. Last stimulus was in 2009. Fortunately, I was involved in one of our real estate company that point of time also. So that was the last time real estate stimulus, and now the some stimulus was given in this year, in 2020 on a pandemic year. So, but apart from that, the support system is not much. People still have to depend a lot on higher cost debt. You go to the bank, generally bank gives to any other industry maybe sub 9 interest rate of interest, and if you go to real estate, they charge you all in cost anything between 12% to 15%. So that's something which is very high. But I option wise, if you ask me, you can take debt from banks. There are few banks who are still giving you debt. There are few NBFCs who are still giving you debt. There some private equity funds are available now. Few private equity funds are now opening. They have started NBFCs here and who are giving big lending tickets. They've done some deals in Hyderabad, Mumbai, Bangalore, even in Gurgaon also in market a large deal has happened. So they're giving the support. That support is there, but options are limited. Let's be honest, options are limited for funding for real estate in India right now.
I think that brings us to the alternative investment funds that has come up in the market with the new SEBI guidelines. So is that a possibility and how far it works in terms of the real estate? Maybe Sneha, if you could just explain what are the, give a brief overview, because these are something new products which not everyone knows about it. You could give a brief overview and how one can take advantage of that.
Thank you. I would like to start with the fact that in any country or any economy of any country, capital infusion is one of the most important aspects to boost the economy of any country. So now, since the conventional modes of investments have become a little stifled, so now the new alternative methods of investments have been explored. Now what? And the most important is that of alternative investment funds, because now the alternative investment funds have been started to be regulated by the SEBI regulations of 2012. And these regulations is mainly, the alternative investment fund is mainly guided and governed by regulation 2IB of SEBI Alternative Investment Funds Regulations 2012. These regulations basically provide for registration of the alternative investment funds with SEBI, then investments, then the mode and manner of investments, the restrictions that governs these alternative investment funds, monitoring and penal powers are also given to SEBI for governing these alternative investment funds. Now, what is the need, or like what is the basis for a country to shift towards this alternative investment funds as a mode of capital infusion for bettering the economy of that particular country? Now, the effect of any capital infusion can be visibly witnessed across any sector in case there is a growth in that particular sector. And one of the most major barrier to the growth of any economy in any country is capital infusion. So, like India, many other countries have chosen alternative investment funds as one of the most effective methods of capital infusion through the private route. And AIFs, the alternative investment funds that is, they actually serve as the best platform for investment purposes. Alternative investment funds are basically, these are privately capitalized investments. They generally pull in money from all the domestic investors as well as from the foreign investors in one particular fund, and then they reinvest those money in various sectors. The alternative investment funds can be in the form of a company, or in the form of an LLP, or in the form of a trust. Generally in India, these funds are set up in the form of a trust, and it is regulated by the Indian Trusts Act. There are also several classifications of alternative investment funds. The funds are now basically classified into three categories. Under the SEBI regulations of 2012, category 1 is category 1 AIF. They basically invest in startups and SMEs, the small and medium enterprises. And the venture capital funds are also there. Then infrastructure funds, like what you call the real estate funds, can also come into the picture. The foreign investors and also the domestic market players, the investors, they invest money in these pools. And the category 1 AIF, which are actually established under the SEBI regulations, they put in those money, they reinvest those monies in the real estate funds. Now, these have very high returns for the investors. So that generally allow the investors, or like pique their interest to invest more through this alternative mode of investments rather than go for the conventional modes of investments. So everybody is exploring these modes. Even the Indian government is also exploring these modes. Even the budget of 2020-21, if you would see, that budget has also created an alternative investment fund allotting 25,000 crores for the stressed real estate sectors, out of which 10,000 crores, as said in the India Union budget, will go for the projects which are actually stalled in the countries. So that will, in a way, infuse funds in all the real estate sector, basically in the real estate sector, thereby enabling those real estate companies to complete the projects which have been stalled due to various factors. And one of the major factors around being COVID-19 situation. RERA has also played an important role. They have granted extension to the projects, but that is maybe at the end of the day not serving enough. Funds are required for completion of the projects. The economy has to roll. So it is the effective mode is now the Indian government has also recognized this. They are setting up funds like this because it is basically what I would say. They are now allowing investors to come in and pull in money so that the real estate sector is upheld and the real estate sector starts booming again. That is how the thing is now working.
So, according to you, is it picking up? What kind of activity do we see in AF so far? Is it happening, or is it more on paper and nothing much on the ground? What has been the scene?
No, what according to my view is the alternative investment funds have now served the purpose that they were set up in. Now they are emerging. It was now recognized in 2012. There were venture capital funds were also there, but now they have been given a platform. They have been now regulated by a legal framework, that is the SEBI regulations. They have served their purpose and it is still emerging as on date. You can also say that the Andhra Pradesh Urban Development Fund has also been established by Andhra Pradesh state government for socio-economic welfare and socio-economic development of that particular state. So in a way, the alternative investment funds have served, they have served their purpose to their best. But with time, there will be more investments coming in. So it will aid in the development of the economy of the country and also various sectors. And when the funds start coming in, the existing new entrepreneurs, then there will be emerging entrepreneurs who will get that financial support and the backing to start their ventures. Moreover, the operational efficiency of a company will increase. And secondly, the production, the manufacturing, the services rendered by the companies who are now facing some financial crunches, they will be getting that economic boost through these investments, and they will now start functioning much more efficiently than they were.
I think one of the other avenues that has helped the real estate sector recently is the SWAMI fund. So, which is something the last mile funding through banks, where banks have helped various developers. So, can you just say whether, based on your knowledge or your personal experience, how the SWAMI fund has been working so far, and how fruitful it is for the real estate sector?
Thanks, Sudhir. I think Sanaisis has covered very extensively how the AIF works. So this Swami fund was also created as an AIF, as a tier 2 AIF, which was created. And I must say that, as a real estate part of real estate fraternity, Swami fund will definitely came as a breath for the entire industry. I still say that's too little, but still something is there for in case of any completely, because there are a lot of projects which is stuck up because of the funds, and the banks does not have enough fund, or they're not enough bandwidth to fund these kind of projects, because many of the projects are already funded by a bank or a institution, and multiple bank after one project closure. Banks generally they don't give another round of funding for these projects. So the Swami fund was created. Swami is basically a special window for affordable and mid-income housing. That's a terminology the Swami is used for. So as name suggests, it is mainly for mid-income and affordable housing segment. It is not for luxury housing. And the best part is it is not specific to any particular category of builders or to any particular cities. So the government has given I think they started the fund. Initially they placed 10,000 crores, and the total fund size for first round was 25,000 crores. So balance was supposed to be raised from investors. They've already raised, I think, more than 10,000 crore, what Sunesis has rightly said, and which I think I now increased to 15,000 odd crores or so. And primarily by LIC, HDFC, and they have funded. SBI Caps is managing it, which is again gives confidence to government that the fund will be properly managed. And till the last report came, around 101 projects were already sanctioned for this, which roughly around covers around some 72,000-73,000 houses, which is a big number for end users when who are looking for houses and they're stuck up because of the funds. And they're across cities, across country. So small cities like Karnal, also Panipat, Nagpur, Chandigarh, Nashik, Dehradun, those kind of cities also are covered in this scheme. Last report, that was a report which was for 10,000, some 500 odd crores. Now the recent report of December says that they have already sanctioned more than 12,000 crores. So it's still quite late because this established in I think November 2019. So more than a year has passed, and there is still a very less disbursement has happened so far. It's only after I think PMO has taken a note of this around 6 months back that they have started acting fast on it. So it's a very good alternative for the projects which are stuck up, and which definitely will help projects to come out of, because there's still a lot of projects where there is still value left in the project, but because of the shortage of fund, the projects is not getting completed. And with this fund, definitely it will help all those projects to come out of red and deliver. So which is the purpose of this particular fund.
Yeah, but the only challenge which I find, I don't know, is that the cost of borrowing here is much higher. Although recently it has been reduced to 12%, but still, if a project is stuck and they have to borrow at such a high rate, so don't you believe that there should be certain kind of discounting or certain kind of subvention from the government to support them here in terms of the cost?
Definitely it has to be, because 12% is a too high a cost. In today's time, if you ask me, real estate does not have that kind of margin. And that also on a express project where they have already suffered because of delay, they have paid so much of amount, servicing to the different banks earlier. And then the 12% has also come after a lot of effort. In fact, I was constantly in touch with Credit. So they came to 12%. In fact, another proposal was also submitted to bring down the cost to somewhere between 10.5% to 11%. In fact, 10% we proposed, we said still bring it to 10.5% or 11%. So which is still not been implemented. And I think the current flow of things, I don't think it looks like it will come down so easily. But definitely we need a good little reduction on interest rate, because see, ultimately the purpose of is to support you. So instead of supporting, if you try to take away all the benefits, then where's the support? Just providing fund. And I've seen the projects, I've seen some of the reports also where some developer has taken the loan, and their servicing and everything will be out of their pocket, because the cost has become so high for them. And you have seen cost has escalated, steel prices has gone to the roof, cement has escalated, aluminum prices has escalated, the cost of material has gone up substantially in last 3-4 months, and it was all affecting the real estate.
Right now with RERA, no, you can't really change the prices to your customers.
Yeah, you can't. Escalation is not permitted. So all the regulations apply to real estate, and the support system is very limited. So that is the irony of real estate industry right now.
Correct. So Snehasi is coming back to you. I think there has been certain changes in terms of the AIF, your norms helps or stifles the real estate industry. What does it actually makes it tougher?
The amendments, I'm sorry, I didn't get your question clearly. Are you talking about the recent amendments?
There has been certain changes in AIF scheme by SEBI.
The amendments are basically necessitated taking into consideration the socio-economic the changes that have come after the law is enacted. So in this case, what has happened is the amendments have been made in October 2020. It has been notified by SEBI, but the amendments are not something which is major, but it has some relevant effect in the manner of functioning of the alternative investment funds. Now, one of the most important and pertinent amendments that have been made is in clause is it regard to the qualification of the key management, or rather the key investment team of the manager of that alternative investment fund. The managers are basically appointed by the sponsors to manage the funds and activities, the administration of the funds, and take decisions with regard to investment teams. Now, every manager has a key investment team therein. So the qualifications of the members have been enhanced to a great extent, so that there is so that people from diversified backgrounds can come in and give their best solutions, as well as render their advice for investment purposes. So the qualifications that have been recently enhanced is that the key investment team of the alternative investment fund, it is stated that one key personnel should have not less than 5 years of experience in advising or managing pools of capital. So the experience factor has been roped in by way of this amendment, which was there, but this has now been made much more stringent, because this has now become the necessity, and it has been mandated by SEBI that one of the members of that particular team, they must have 5 years experience at least in managing and advising the pools of capital. Then there is also the amendment that have been introduced, or rather the changes that have been made, is that one key personnel of that investment team must have a degree in accountancy, business management, commerce, economics, capital market from any recognized government, state government, or any foreign university. So that actually brings in a lot of mileage for the team and basically the managers or the alternative investment funds to play around in this market. They can garner a lot of investors by sharing their experience, knowledge, and skills. That's how the amendments have been enhanced, and that's how they have been roped in, so that the investors actually find comfort in seeing that the team have experienced personnel involved, and their money will not go down the waste basically, and that the suitability of the investments will be also taken into account, and they will be much more interested in investing sums in the fund. And then the second is that it's one of the most important amendments to be, should I put it like that? One of the most important amendments is earlier, prior to the amendments in October 2020, it is the manager of the alternative investment fund who are held responsible for any policy decision or decisions pertaining to the investments that have been made. But after the recent changes in the SEBI regulations of 2012, what has happened is, along with the manager, the investment committee, there is a committee that is formed by the manager. The the committee, they are also now been held equally responsible for any policy decisions that is taken by the alternative investment fund. And secondly, they are also now jointly and severally liable for any policy decisions and compliances of the regulations. So that is an additional responsibility that is now given to the members of the internal committee. So that is how the amendments have now shaped forward. And then external members whose names do not feature in any of the documents, any of the fund documents, like if it's the trust deed or the placement memorandum or anything, they are also now included in the committee. So all these changes have now been brought in, and this is one of the major change, because now the members of the committees have now been also can be held accountable for any of the decisions or any of the compliances. If the fund doesn't perform well, or if the fund doesn't comply with the SEBI regulations, they will be held accountable for it. These are the major changes.
I think the idea here is to make it more professional, more accountable, and more.
Yes.
Yeah. Although you have a future professional work opportunity, becoming an advisor and member of the committee.
In fact, as a company, we also initiated, because we're FDI company, we anyway has to raise capital outside India and deploy in India. So AIF provides that opportunity also to us. And I think I agree with Snesi, the kind of regulations has come up. And with the AIF coming in, it's definitely a much more transparent structure than the ECB route, what was there earlier available. So it provides a lot of flexibility in terms of raising and repatriation of fund, which is a good sign, because ultimately any FDI which is coming in India, they look for not only investment and returns, but also ease of taking the money back as and when required, which is very important for them before they invest in India.
One of the more important thing, although not maybe very critical, but still it has helped in real estate, is the ECLGS line, which has been made available now. So emergency credit guarantee line scheme. So which is basically the 20% of your outstanding loan as on February 29, 2020. So this has given additional funding to the real estate sector. I think that is one of the important support pillar which is helping not just the real estate industry, it's actually for the entire economy as a whole. The government has given that's only available up to I think 500 crore of loan, so not more than that. So, but still there are large number of mid-sized developers who are able to take advantage of incremental funding based on their outstanding as on 29th of February. 20% is a fairly decent amount of incremental funding which is available without any additional security. So I think that is also.
Yeah, sorry.
Yeah, please continue.
No, but I think that definitely will help. Though I have not seen many developers opting for it or getting it, because I know for sure that few proposals are not accepted by the bank under this. They said that real estate, we don't have a mandate to or internal policy to give to real estate any additional funding for under this scheme.
But there are transactions happening. I'm aware of it, and there has been the only thing is that because there is no additional security required. I think these are the new innovative area support that the government has given to the sector.
In fact, they have given one more stimulus that last time they gave for moratorium in payment of interest and principal during the I'll say lockdown period, and beyond that also. It definitely has helped a lot of developers, because that period was really tough. Inflows are not coming, and then still if they have to serve, so that would have been a really disaster for the industry. So that some people.
Yeah, there was a big relief for the entire industry, definitely for real estate, and in fact, I would say for overall economy as a whole.
Correct.
It was a big relief.
Correct.
So coming to some other part, real estate investment trust. So we today we have a listing of Brookfield REIT also going on. Their transaction is their public issue is open. Brookfield has gone public with their recent REIT. Embassy has also gone for developers who have done that. So Snehasis or Atul, maybe any of you, if you could add that, how does this REIT scenario looks in future in terms of asset class, both from investor perspective and both from developer and also from developer perspective?
So I just start. I think Snehasis, then you can add on. Because REIT Brookfield IPO is closed today. Now 3 p.m. is the last call for investment in REIT Brookfield, and I heard the numbers are coming good for Brookfield. And because REIT provides a good investment opportunity without investing in hardcore real estate, you still get the benefit of real estate by buying units. So that was a long-standing demand for India, because all over the world this works very well. And it came, I think it came at the right time in India, where commercial market was slightly sluggish, and this is definitely helping consolidation of real estate portfolios for a lot of developers. I heard a lot of more developers are coming with the REIT. In NCR, I think DLF is coming with one, and others will definitely follow the suit. So it provides that option of listing your real estate commercial portfolio on a bourse, and even a small person who has a small amount can invest and take the benefit of investment through REIT and getting the benefit of commercial portfolio as part of their one of a wealth portfolio. And so that something helps. And this budget also, given that there's one anomaly of withholding tax on REIT's dividend, so that is removed in this budget, so which definitely is helping REIT now, because otherwise the cash flow is getting stuck in withholding tax. So that's something is good. So I see that government is open for changes, and they're coming up with these small changes to make it more practical and implementable, which and commercial REIT definitely is with my experience is that my thought process is going to be a all the big real estate portfolio that you see across India will be converted into REIT one day or other, because that is the ultimate exit option for all the big players who are holding large assets and still managing those assets. And because that's the biggest challenge for any commercial developer is that once they part with a commercial asset, it goes into high net worth individuals' hand, and it becomes very difficult to manage those portfolios. With a structured option like REIT, it will definitely help them to exit out from the commercial portfolio and still see that the portfolio is properly managed.
Yes, would you like to add something?
Yes, I may add to what Mr. Bansal just said, that the developers under this REIT regime, they feel a little bit more secured also, in the way that the funds that are now generated, the REITs, they actually buy a stake in the development project, or rather in the developer itself. Now, if the projects get stalled, or if they are unable to complete the project, the fund actually takes over the project. But there is no fear of any winding up or insolvency being faced by the developers per se. So in that way, REITs also help the developers to explore that possibility, so that their development takes place in a proper way and in a shaped manner, and then there is no threat of any insolvency or winding up of the company at large. So that is my view with regard to this, in addition to what Mr. Bansal said.
I think that's fine. I think that's a way of alternate income for individual also, and that's like diversifying one's portfolio from investor perspective. So that is also a very good opportunity, which was right now not there and missing. So I think it works from a developer perspective. It works from investors, whether it is HNI investors or foreign investor, or it also works from individual retail investors. So all creates a kind of win-win scenario. Well, it's like unlocking of something which is right now locked for a very, very long time. You unlock that value, and the best thing about REIT is that developer can focus on what he knows best, development of another asset. So if he's stuck in a commercial asset, then his money is stuck for next 20 years. So he can unlock that, and he can definitely use that money for the development, which is his best bet rather than anything else. So that's a very good thing. Now coming to private equity in real estate. So what there has been some transactions, but these are more towards commercial real estate, and they have come into big play. So do we see opportunity more in terms of residential, or this will be more restricted towards commercial only?
Private equities in India, see, it has a long history of private equity investment in India. And real estate being a major share, was taking a major share, but though it is not being like that in 2020, I think our private real estate and private equity investment in real estate, I've seen last year, I think it was fallen down by roughly around 40%, mainly because of pandemic and weak market perception for real estate. And private equity also has evolved over a period of time. Initially, see, in early, I'll say 2000 after 2005-06, when the real estate boom has really started in India. After that, most of the investments was coming in India was in the form of equity. A lot of big institutions had opened their offices here in India, and they invested through India offices, through their offshore entities, and they all invested in equities. But now, most of the private equity funds which is coming in India, and particularly real estate, they are all coming as a structured debt. So they charge a coupon, and they look for an upside, and the returns expectations is very high. So that provides sometimes a good. They becomes a good, I'll say, brand ambassador for a project or for a company if they invest a big, P players coming and investing into a real estate project or real estate company. So that gives them a good boost in the market, but obviously the cost is very high. So that's something which has over a period evolved into a more a debt than an equity. But having said that, still the money which comes in very handy, because they have a flexibility of investing even the early stage of a project, which generally banks or financial institutions in India cannot do because of the RBI regulations, obviously. So they have and with like I mentioned in my initial thought also, that a lot of these international companies has opened their new NBFCs, has come up, new private equity funds has been set up in India, which now investing big time. We have seen one of a large private equity fund getting completely busted also. I don't want to name them, but they had to exit out of India because of the bad investment that they had. But again, one of their investors only opened a big shop in India. They're investing big all over. They have large transactions that has taken place. So which shows the confidence is there for a private equity market to invest in India, though the real estate takes only 11% of total PE investment that is coming to India. But still, the option is there, and anybody who's looking for a big fund requirement, so private equity is the only option for them. And definitely with the kind of options available, they can look for more of such opportunities.
Rajesh, you have any thoughts to add there?
Recent trend and the policy reforms also enacted by the government, it also suggests that there will be a substantial boost in private equity in real estate in 2021 rather, because in 2020 all the economies were under extreme stress. So in fact, private equity also suffered the brunt of it. But the policy reforms have now been brought in by the government. They are also trying to monetize every sector, like the real estate sectors, also through private equities. So there will be a general growth in this sector. That's the recent trends suggest, as well as the reforms that are being brought in by the government.
I just add one more thing what Sanesi said. I completely agree with what he's saying. I missed that point also, because on this budget, Honorable Finance Minister has removed FPI lending into debt. So earlier it was not permitted. So now in real estate that is permitted now. So that is a big boost for any FPI wants to directly invest as a debt in India. So they can do that now. So which definitely is going to help all the because earlier they were supposed to open a company here, make it capital, raise capital here in India, or provide capital from outside and then invest. Now they can invest directly from a FPI unit outside, so which is good, which definitely going to help.
Any wish list that we would like to see in the near future?
Sorry.
The sector.
Sorry, I missed.
Any wish list?
So see, real estate wish list is quite long. Honestly, if you ask me, I'm sitting with a list of a lot of. It's a laundry list I have for real estate. See, the biggest right now is that controlling prices of materials, which is skyrocketing, which is going to affect not only real estate but the infra projects also. Secondly, the most important is ease of doing businesses, which was the motto of this government, but which is not yet implemented. We still are subject to multiple regulations at multiple front. RERA is there. RERA is supporting more to the customer than to the developers. And so this is one more authorities coming in. Every regulator has a different work style, work policy. We have to because we are subject to all kind of regulations, but a timeline. There is no timeline for them to act on our project, but we have a timeline to follow in RERA, so that ease of doing business is very important for us. Thirdly, the most important is fund availability. All of these big companies, all of these big countries, they all succeeded because the banks supported development of real estate in their country by providing a easy capital and at a reasonable cost. So that's something which is still missing. It pains me sometimes when I go, outside and see those developments. We're not able to do in India because of the reason that we can't afford, we don't have access to a good capital or a reasonable value capital. So that's something which hurts every real estate developers in India.
I think reforms both in terms of regulation and support of funding, that is where the key is. I think with this, I would throw back to Samriddhi for some questions if there are from audience, and maybe some based on that we can have some concluding remarks. Samriddhi, you are there?
Yes, hi, I am very much here. Thank you once again. I think with that, we'd like to close the session if we've taken the questions. And we'd like to thank all of our panelists here for joining us this evening and talking to our audience. And the questions that we have received, we will ensure that we'll get the answers to all of those questions and get back to our audiences on that. So thank you, everyone. And with that, we come to a close of our today's agenda. For tomorrow, I'd like to tell our audiences that we are going to start at 11 a.m. With a session on the contracting conundrum, and which will be followed by a session on imagining tomorrow, the sector wish list at noon. So we'll request all of you to please join us once again tomorrow at 11 a.m. At the Lex Witness 9th Annual Real Estate and Construction Legal Virtual Summit Edition. Till then, please stay safe, stay healthy, and take care. Good evening.
Samriddhi, just give me a minute. Sudhir sir, Atul sir, and Snehashish, we have a few questions in the Q&A box.
Okay.
Although they might not be directly related to funding and finance, but it will be great if we can get some insights from you as far as those three questions are concerned. They're somewhat related to RERA.
So one of the questions that I can see is on post-enforcement of RERA, all most developers are still using the age-old practice of one-sided agreement and hardly giving any scope of change in the standard agreement per se. Your views, Lucy? Honestly, I feel that because now none of the developers can violate RERA, because RERA has a very standard set of agreement which has to be adopted by all the developers, and any project which is registered in RERA, they have to submit their format of agreement with RERA. So I don't know whether if there is still mistakes on the part of developer, it should be corrected, or it should be brought to the notice of RERA or to the management of developer company, and they have to adopt the changes, because nobody, as a developer, I cannot escape from that liability. Even if I am doing a mistake, I cannot get away with that, because RERA has a very clear-cut system. There is a rule book, there is a bylaw, rules have format of agreement which has to be adopted. You can tweak some changes based on your specific project requirement, but ultimately it has to, basic framework has to be as per RERA agreement. And every registered project has to submit the RERA the agreement which we are signing with the customer to in the office, in the RERA office also. So if there is a mistake, it has to be corrected. It should be corrected.
I think there is one question regarding although it's a legal one, but still maybe let me try to address that. It's on the implementation of the RERA orders. I think that is something comes from the intent of the developer. See, if the developer doesn't have money or doesn't have intent to develop and hand over the project, we've seen large number of RERA orders, NCRDC orders being given but ultimately not implemented. I'm not being biased towards the developer, but in most of the cases, developer actually don't have money. If you order a developer to refund the
We lost you, Sudhir, I think.
Cannot hear you.
Money back to the buyer, how does he do that in the project? So I'm not saying that. I think there is some network issue. Now you can hear me?
Yes.
Yes.
Network. So there was some network issue. So I was telling that, if the developer actually doesn't have money, although he may have diverted earlier, but right now he doesn't have money. So the only thing you can put him in jail, sell off his private property, and making sure that to that extent the order is implemented. But beyond that, you can't actually do anything about it. So that's my view on the implementation of the RERA orders from legal angle.
Hello.
You can hear me? Yeah.
Yes. Yes.
So on the implementation of RERA order, do you have any views? There's one question posted on that. How do we ensure that?
See, when any order under the RERA Act is passed, the developers normally get 45 days of implementing or rather complying with the order. But in most of the cases that we have seen from practical experiences also, the developers, as you said rightly, are not in a position to make the payments because of the funds issue or the financial crunches that they keep on facing at regular intervals. But what is the option that is legally open to them is to first, to the customers, I say, is that they can also send legal notices through their attorneys to the developers calling upon them to make the payments. And at best, they can go up and file execution cases. That's the best that they can do. Otherwise, there is not much that can be done on the legal front except for execution and attachment of the properties of the developers, companies, and etc. And that is how they can get the monies back. And that's the best thing that is available to all the customers anywhere in the country and under the applicable laws.
I think that's it from us. Somebody, you have anything?
No, nothing at all. I think with that, we close the session. So thank you once again. Thank you all.
Thank you. Thanks a lot. Thanks.